We'd sit in there for 2 hours.
Really?
Yeah,
In the cooler.
right in the beer cooler, and he could look out and see what was going on. It's that time again, thinking real estate. Laura Dwyer Schlecke on assignment again.
Yeah, I don't know in which far-flung locale she happens to be today. But
Doesn't make any difference. She's not here.
if she's not here today,
Well, she should be.
She wasn't here last week either.
That's right.
Remember that? Okay. But
She's still around?
You know what? I haven't seen her in like a couple of months. Not since we got back from vacation. Yeah. No, she said, just as I was leaving the house this morning, she said, oh, by the way, can you do the radio show on your own? I said, well, I don't have to do it on my own. I have Jackie and I have Mr. O'Connor to assist. So, and thanks for the weather today, by the way.
Yeah, it's going to be a
It's awful.
rough week for golfers.
Yes, indeed. And my
And
golf
baseball
game,
players.
was really starting to come around too. That was the bad thing. So,
Hang on to that thought.
yeah. Hey, I was asked to talk about deeds today, by the way.
Really?
Yeah. I happened to see somebody who asked not to be mentioned, and the issue has arisen, and it's not a new issue, but people who sell property on land contract. You know, I mean, you know what a land contract is, right?
Kind of.
Kind of.
What is it?
It's just a financing device where the seller doesn't convey legal title to the property until after the purchase price has been paid. It's an installment contract is what it is, like a mortgage, but different in that the seller holds legal title until the balance of the purchase price gets paid. Could be a 2-year land contract with a balloon payment, could be a 5-year contract, 10-year contract, doesn't matter. But there is a device that sellers and sellers' attorneys who don't know any better use to what they think will get them around foreclosing the land contract. Because if a land contract goes into default, I have 2 options as a seller on a land contract. I have the option to forfeit the contract, and that's a process which is actually the same process as evicting a tenant. There are just some different rules, but that's done in district court. And I send out a notice of forfeiture. Matter of fact, years ago I would have to send what's called a notice of intent to forfeit, and then I'd have to do a notice of forfeiture. About 20 years ago, the first of those was eliminated. So I send out a notice of forfeiture, and then if the land contract isn't brought current, and now I'm talking about, let's say I've got a 10-year land contract, and it goes into default, monthly payment of $500, something like that, doesn't get paid. So the land contract vendor sends out a notice of forfeiture. The vendee doesn't pay, the purchaser doesn't pay. So now the seller has to go to the district court in what's known as summary proceedings to recover possession of real estate. Same thing as a landlord. But in that process, what happens is we go to court, I get a judgment, but now the purchaser has, if the purchaser's paid less than 50% of the total purchase price, not the land contract balance, but the total purchase price, then the period of redemption in which the purchaser has the right to bring the land contract current is 90 days. If 50% or more than of the purchase price has been paid by the purchaser, then there's a right of redemption or the right to bring the contract current of up to 6 months. So it's 90 days. If it's less than 50%, 6 months. So in other words, the point here is if you do a forfeiture as a land contract seller, it's going to be a period of time before you get the property back. And the disadvantage of a land contract forfeiture is, there are actually 2 of them. One is I cannot accelerate the balance due, so that if I've got, let's say it's a $50,000 land contract and only a payment or 2 or 3 are in default, I can only sue for the payments in default. And all that the purchaser has to do is bring those payments current. So if I've got a continually defaulting land contract purchaser, as a seller, I'm going to constantly be doing this process. They bring the land contract current, go into default, and I start it over again. That's one of the options of a land contract seller. And if it's a short-term contract with a balloon payment, and it's the balloon payment that comes due, now the forfeiture can work better because they've got to pay the entire balance off. The other disadvantage of a land contract forfeiture, though, in the district court, is that the seller cannot get a deficiency judgment, so that if the property has declined in value or They've trashed it, so it's now of lower value. But if the property is worth less than what the balance is on the contract, I can't get a deficiency judgment. I just get the property back. That's a forfeiture. The other option that a land contract seller has is to foreclose the land contract. And foreclosure allows the seller, typically a land contract will say something like if it's in default for more than 30 days or in default for more than 45 days, that the seller can accelerate the entire balance due. Now, the purchaser can't just bring the payments current, they have to pay off the entire balance. The disadvantage of the foreclosure is it's a circuit court proceeding. I get into the circuit court process, I actually have to have a foreclosure sale. The period of redemption after that foreclosure sale is 6 months, so that's a much longer process to get the property back. But I can do it once and for all. They can't simply bring the payments current, and I can get a deficiency judgment in that process. So now, understanding that as a land contract seller, if I want to enforce that contract when it goes into default, I've got to go through one or the other court process. What some sellers do, what sellers who don't know any better, and their lawyers who don't know any better do, and this is actually quite common, is the seller and the seller's attorney, they, as a condition of the land contract sale of the purchaser, they have the purchaser sign a quitclaim deed that is put in escrow with the title company or held by the attorney, so that when the contract goes into default, the deed is then released to the seller and the seller records the deed. It appears on the public record as if the purchaser has now reconveyed his or her interest to the seller. It's a device to try and avoid forfeiture, foreclosure. The problem for sellers and sellers' attorneys is it doesn't work. Our law prohibits a land contract
Why would you do
seller
that then?
because they don't know any better.
Really?
Yes, they just don't know any better. The seller doesn't know any better, and the seller's lawyer.
They
who
should
doesn't
take
do
your
real estate.
class.
They should take the class,
Yeah.
or they should talk with a knowledgeable title company representative. You know, you could talk to any of the local title companies.
Like Ron Ellison.
Like Ron Ellison,
Okay.
Bob Newman, but I don't want to say, look, they're both good
They-
friends of mine, but
they
I
know-
don't want to cut Mid-State Title out of the mix either, or other title companies.
Right.
I mean, they're good, they're reputable title companies. The two we happen to use are Mid-State and American, but that doesn't mean there aren't others out there. I don't want to throw aspersions.
Are there
on
others
title
out there?
companies. Yeah, there are title companies. There are other title companies. Yeah, but the two main ones in town are Mid-State and American, at least as far as I know. So anyway, my point here is that Michigan law and the law in other states, we zealously protect the rights of a land contract purchaser to be able to retain the property, that it can't just be forfeited out from underneath the purchaser by this device of a quitclaim deed. It's completely invalid, completely unenforceable, and as I say, sellers just don't get it sometimes.
Now you hear that, I don't know if it's quite often, but somebody's selling a business and they end up getting it back.
Mm-hmm, yeah.
Is that, how would you describe that? Frequent or?
It was frequent in the recessionary times, particularly where a sale took place just before, let's say, 2007, 2008, or took place before what was the prior recession, let's see, early 90s maybe, and then before that, early to mid 80s. So what would happen is sellers of small businesses particularly would sell the business, sell the land and building on land contract, sell the business itself on a promissory note. The purchaser would take over, and then the purchaser was unable to make the payments, so now the seller of the business has to take the property back and take the business back. Yeah, there was quite a bit of that happening as a result of the recession, and again, a lot of it
Is
wasn't.
it as simple as not making the payment?
Sometimes it is. Sometimes it's. Yeah, I mean, the payment doesn't get made. There are other defaults in terms of sales of businesses, but I'm sitting here thinking about it, and it's always the failure to pay that results in the seller taking enforcement action. And then usually often the purchaser comes back and raises a defense that there was a misrepresentation as to the quality of the business, the quality of the clientele, the volume of the business, dollar volume of the business, that sort of stuff happens all the time.
That's tough, isn't it?
Yeah, that's a tough claim to make on the part of the purchaser, because pretty much, Michigan law is that a purchaser of real estate takes the real estate as is.
Yeah.
And that would also be true of personalty, whether it was tangible personalty, personal property, or intangible personal property. As a purchaser, you really have to do your due diligence. Matter of fact, there's a recent case just decided within the last year in which the purchaser went after the seller, went after the seller's broker, went after the buyer's agent, claiming that they all misrepresented the value of the business and the value of the property. The court came back and essentially said, hey, look, you know, even if the seller negligently or innocently misrepresented certain facts about it, nevertheless, you, the buyer, had a duty to exercise due diligence in researching that business and in researching that property, and you weren't relying, or you weren't justified in relying upon what the seller or the seller's agents were telling you.
So you should never rely on that.
I wouldn't rely upon it. Where I represent somebody who's buying a business or who's buying a non-residential property, even a residential property. You got to understand that Michigan law really imposes a duty on the buyer in many, many respects, and the buyer has to exercise due diligence. You got to investigate the environmental condition of the property. You got to investigate the physical condition of the property. You got to investigate the value of the property. You have a competent market analysis or appraisal done of the property to determine its value, and those duties rest upon the purchaser. Now, and then we've talked about this before, the seller's duties to refrain from committing fraud. I mean, if the seller commits fraud, then the purchaser may have a claim. But even if a seller makes a misrepresentation about the property, even an intentional misrepresentation about the property, our law in Michigan says that if the purchaser saw or had the ability to see or determine this particular defect or problem with the property, the purchaser was not entitled to rely upon the representation of the seller. The purchaser has to rely upon his or her own inspection of the property and the inspection by his or her experts. And we always do that with the due diligence. I have a case going on right now in which my client actually bought land back in the late 80s, and then in the mid-90s built a factory on the land, and they added a parcel in the back. Turns out the parcel in the back was part of a former city landfill, and so now we've got environmental reports that were done within the last 3 months in connection with a possible purchase or sale and purchase of the property, and they've discovered methane from the old landfill in concentrations high enough that it's explosive. How would you like them out?
Like that in your backyard.
Yeah, well, I guess you got a free source of energy for the next umpteen years as the landfill, all that material biodegrades and creates methane. So, yeah.
Like Hiroshima.
But, well, hopefully not as bad as Hiroshima.
Yeah.
Okay? But, yeah, I don't want to go start talking about Donald Trump and nuclear weapons. But,
No.
but the point is that was in, here they built it in 1995, and in 1986 is when the federal law was changed that imposed on a federal level the requirement that purchasers of property exercise due diligence, make reasonable investigation into the environmental condition of the property. But that's just the environmental condition. I mean, there's so many other issues that purchasers of businesses and purchasers of real estate face.
So can you just let the payment slide and so you want to get out of it?
As a buyer,
You just let it slide and that's going to be it?
No, because because if the seller retained
Can you be
competent
sued?
legal counsel, yeah, absolutely. Let's suppose that I sell the business for $1 million, right?
Yep.
I sell the business. Forget about the land. I just sell the business for $1 million. Purchaser puts $200,000 down. As a seller, I finance the balance on a promissory note, $800,000 on a promissory note payable over the next 10 years. Interest rate at, let's say, 8%, 9%, whatever it may be. I have to be concerned about usury laws, but this is a business. I can go up to 15% if it's in connection with business loan, sale of the business. So anyway, so I do it 8%. The purchaser gets in there and the business falters, finally fails, and so the purchaser says to the seller, hey, just take the business back. But at that point, the business is worth, let's say, $200,000. If that, maybe it's almost worthless. The knowledgeable seller and knowledgeable seller's attorney, they've wrapped that purchaser up in terms of security with respect to the business, security interest with respect to the business, and then personal loan, personal guarantee by the purchaser, so that business now sells, the seller takes it over, they sell the assets for 200 grand, there's $600,000 balance on the note, go after the purchaser for that personal guarantee. And if the purchaser, in doing due diligence from the seller's side and selling where the seller finances it, the seller is determining whether or not the purchaser has the economic capability to pay off that personal guarantee or to honor the personal guarantee. And if he or she doesn't, I'm going to insist upon co-guarantors till I get sufficient guarantees so that if that business isn't worth what the note balance is, I have the ability to go after.
Now,
the personal guarantee.
if you don't do that up front,
The legal term is you're screwed.
yeah,
Yeah, that's a legal term of art, okay?
exactly.
Yeah, you're gonna go, there's
Yeah.
another one, you go suck an egg, right? Yeah, no,
Yeah.
from any time I've got a seller who's financing a sale of business or real property, you gotta exercise extreme due diligence to determine the creditworthiness of the purchaser, how solid is that obligation to get paid off. And if there's a doubt about it, as a lawyer, I mean, I have to really sit my clients down, my sellers down, and say, look, I know you want to sell this property. I know it's important. It's been sitting on the market. But what you don't want to do is have a sale in which all that happens is a year from now or 2 years from now, you get the property back. Okay? Because many purchasers balk at giving a personal guarantee. They don't want to do it. It's got to show up on their balance sheet as a contingent liability. And they don't want to give it for a whole variety of reasons. But from a seller's perspective, don't just make a sale because it's a sale. Make a sale that is a good sale so that you're not going to get the property back, or there's little likelihood that you will.
You got any houses, Jack?
We do. We've got a listing at 3420 Lookout Circle, listed for $159,900. We've had a lot of activity on this house lately, so people must be out there looking. But we still need a buyer. 4 bedrooms, 2.5 baths, over 2,000 square feet. Great floor plan, great location. 805 Southwest Avenue, 154.9, 4 bedrooms, 2 baths. I'm sorry, 1 full bath, 2 half baths. That one's over 2,500 square feet. That's a huge house. It's great location as well. And then 2654 Virginia Court, if you want to be near Clark Lake, that's a great opportunity for 161. Give us a call, 780-3800.
And Laura, wherever you happen to be, just understand that Jackie and I, we love you, we miss you, and we hope that you return soon. Thanks, Greg.
See you next
See you
week.
next week, man.
Text at 597.